I am delighted to welcome you to the Judge Kenneth W. Starr Federalist Paper Lecture Series presented by John and Marie Chiles. This year, we are honored to welcome U.S. Supreme Court Justice Brett Kavanaugh to Baylor University. Dean Counselor is going to share an introduction of Justice Kavanaugh in just a few minutes. Before we have the privilege of hearing from Judge Kavanaugh, I do want to recognize some of our special guests that are with us today. The Judge Kenneth W. Starr Federalist Paper Lecture Series is made possible through the generosity of John and Marie Chiles. Because of the support of the Chiles, Baylor Law students have had the opportunity to learn from leading legal scholars since 2014. John is a two-time Baylor alum, including from the law school, and Marie is a Baylor alumna by choice. They have been some of Baylor's most loyal benefactors for more than 50 years and have been longtime advocates of Baylor Law School. In 2012, they were awarded the Founders Medal, which is the highest honor that we give from Baylor University. John and Marie, we are so grateful for your generosity, for your support, and for making this event today possible. So thank you so much. I also want to recognize Dr. Johnette McCowan, the president of McLennan Community College. Johnette is a dear friend and a wonderful partner with us here at Baylor in so many ways, and we appreciate how Dr. McCowan and MCC have worked with Baylor Law School to bring Justice Kavanaugh to Waco. So thank you so much, Johnette. We really, really appreciate it. And finally, I want to recognize Mrs. Alice Starr. Throughout their years in Waco, Alice and the late Judge Starr used the many relationships they had built through their years of service to our country to bring U.S. Supreme Court justices, secretaries of state, U.S. attorneys general, constitutional scholars, and many other luminaries to Baylor University. We are so grateful for Mrs. Starr's support of this event and for her continued commitment to educating Baylor students for worldwide leadership and service. So thank you so much, Alice. We're grateful to you. It was just a year ago that we launched our strategic plan, Baylor in Deeds. It is a plan that details how we are using our position and influence as a Christian Research One university to impact the world for Christ. Throughout the strategic plan, there are 4 imperatives that we believe are essential for Baylor to succeed in our global world today. One of those imperatives is around civil discourse. We live in a world of increasing discord and conflict. The tragic events of yesterday are an all too clear reminder of this, as is the fact that today is recognition of the event that occurred 24 years ago on 9/11 when those horrific events happened. We want Baylor to be a leader in preparing active, engaged citizens who interact with others with civility and with respect. We are committed to helping our students, faculty, and staff grow in having healthy conversations across differences. Today's lecture is a wonderful opportunity to hear from a distinguished jurist who is shaping and influencing our nation today. I know there are a broad range of backgrounds and political beliefs represented in the room today. I appreciate your willingness to listen with grace and understanding. I am glad that each of you has made time to be with us today. So now it is my pleasure to ask Judge Kavanaugh and Dean Counselor to join us on the stage. Thank you all so much for being here.
Well, I am pleased to have a guest at Baylor University who needs no introduction, but I'm going to give him a very brief one so that we can dive into the conversation. Of course, Justice Kavanaugh is a United States Supreme Court justice, having been appointed by President Trump in 2017. He's also a graduate of Yale College and Yale Law School. He's a former Supreme Court clerk and on the D.C. Circuit before you joined the United States Supreme Court. So Justice Kavanaugh, welcome to Baylor and welcome back to Texas, something I want to get to in just a moment. But I didn't plan to start this way, but I think in light of the apparent political violence yesterday that we've all learned of, and in light of polarization in our political discourse, and this is a lecture series about the Federalist Papers, and in Federalist number 1, Hamilton says, in encouraging the adoption of the Constitution, he frames the issue this way: it's whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force. And I think many Americans worry about the political violence, the political polarization, and I know you yourself have suffered in your family because of this. And I'm just wondering what you would say to lawyers and future lawyers about what we can do to bring the temperature down and improve civil discourse.
Well, thank you, Dean. Yesterday was a dark day for America, no doubt about it. There's no place for violence, political violence in America. And I loved what you said, President, about Baylor being a leader in civility and respect for other people's points of views and bringing people together in conversation. And I think all of us in America need to recommit ourselves to doing that, to a culture of civility and respect for others. And it's a dark day, no doubt about it, but I think we just need to do that. I said last week, I was speaking at the Sixth Circuit Conference in Tennessee, and said tone matters in what judges do, and I think in what we do on university campuses as well. And just all of us need to foster that culture. And I appreciate, again, what you said in terms of Baylor being a leader. And Baylor has always been a leader in that. And I think that is a great tradition of this law school and this university. And the Supreme Court tries to live up to that too in terms of how we conduct ourselves. So appreciate the opportunity to say that. And of course, first and foremost, prayers to the Kirk family. That is just a horrific episode in American history, and think first and foremost about them.
Something we can do is have a civil discourse right now. So I'll start with something that always I enjoy talking about, which is Texas. And I know you have some Texas connections, so maybe you could talk about those. And I would ask that you include in your explanation, what is the 100-degree club?
Right, yes. Well, my wife's so excited I'm here because any opportunity I have to be in Texas, she thinks is good for me. My wife's from Abilene, Texas. She went to Abilene Cooper High School and then went to a different university for undergrad, which is down the highway a bit, University of Texas at Austin. When she was a junior in college, she got an internship with then Governor Bush's office, and she ended up working on the Bush campaign in 2000 and moved up to Washington as his personal aide. So she was the person who sat directly outside the Oval Office, which was a great job and very interesting and very stressful. And we met in the White House. I was in the counsel's office, and we got married, and she's still waiting for us to move back to Texas, which seems unlikely at this point. She's a proud Texan. And then I worked for President Bush and all the Texas folks who were part of his, of course, White House staff. And when I had the job called staff secretary, which I had from 2003 to 2006, I traveled with him everywhere in the country and the world, whether it was Moscow or Beijing or the Vatican or Buckingham Palace or Afghanistan or Crawford, Texas, and spent a lot of time on the ranch with him in Crawford. He would come down for a couple weeks in August, usually around New Year's, and a few other times during the year, and stayed in a double-wide trailer on the ranch at Crawford, which was great. But every afternoon, he would wait till the temperature got above 100 degrees, so usually about 1 p.m., and he would have a 3-mile run, And if you made the 3-mile run without collapsing, without walking, you got a T-shirt at the end, 100-degree club, President's 100-degree club. And I have those T-shirts proudly at my house, preserved. I don't wear them anymore. I try to preserve them as a member of the 100-degree club. But President Bush was really a West Texan as well, like my wife from Midland, and a proud Texan. And it was great to be part of his staff and to learn from him. I could talk about, if you want, him and September 11th, but I don't want to get in front.
I have a specific question about that because this is the 24th anniversary of the September 11th terrorist attacks. And I'm kind of wondering, how did you find out about them? What were you doing? And then what did you see in terms of the reaction of the president?
At the time, I was working in the White House counsel's office. I was in my office, and I remember exactly. We then all congregated in the White House, Al Gonzalez's office in the West Wing, and then we all went down to the mess, which is in the basement of the White House, and then the Secret Service came in, so we got to evacuate, and we literally went out on West Exec Drive, and the Secret Service was yelling at us, run, run, ladies, take off your heels, sprint, because they thought what turned out to be Flight 93 might have been coming for either the Capitol or the White House. So I remember the full sprint out the gates that day. I remember the aftermath. No communication at all then. But more generally, what I remember, that's the central government political event that I remember in my lifetime to this day. And I know a lot of the students didn't experience it. And every September 11th, I think about it quite a bit, and a lot of other times during the year. For President Bush, I think about on September 12th, 2001, he came into the Oval Office and said, "This will not happen again. This will not happen again in America." And he wanted the country to move on, of course, and get back to normal eventually. But I always think about his presidency and seeing him up close as I did for many years. For him, every day for the next 7+ years was September 12th, 2001. Every day was, I wake up and my job is to protect America and to protect Americans from having this happen again. And he made a lot of tough decisions. The presidency, our job's hard now and then as judges. Presidency's a lot harder. You got the safety and security of the American people as your responsibility. And he knew if there was another attack, people would say, "Bush, why didn't you protect us? Why didn't you do this and that?" And he made a lot of tough decisions, all, in my view, well-intentioned to protect America and protect Americans from another terrorist attack. And I have the greatest respect for the presidency, the burdens of the presidency, and for President Bush in particular, for how he led America through that. Every September 11th, I did it yesterday, but every September 11th, and I encourage the students to do this, I watched a bunch of videos. I watched the video of his calling Governor Pataki and Mayor Giuliani on September 13th, where he chokes up at the end. He says, "I'm a loving guy, but I have a job to do." September 14th, watched the speech at the National Cathedral that morning of September 14th, 2001. Watched the moment, which I think, is just a great moment in America, when he was on the rubble in New York on the afternoon of September 14th, 2001. And he said, "I can hear you, the rest of the world can hear you, and the people who knock these buildings down will hear all of us soon." And the roar of USA, USA. His speech to Congress, then I watched yesterday, September 20th, 2001, where he starts with Lisa Beamer, the wife of Todd Beamer, who had rushed the pilots on Flight 93. And, if you don't choke up watching that, it's really quite extraordinary. And then, of course, the end of the story is of that particular piece is, of course, when when President Obama gave the order, very courageous by President Obama, to give the order to take out bin Laden. And, there's a movie, Zero Dark 30, about that, and a new documentary about that. President Obama deserves a lot of credit for that. But that occupied, constantly in his mind, protect America. And that's a huge burden for a president to carry. And I saw that up close, and proud to be associated with President Bush and and grateful for all he did for me.
I want to ask about someone else that I think looms large for you, and this is something we have in common. We both had the opportunity to work with and for Ken Starr, for whom this lecture series is named. I wonder if you'd share some reflections on the influence of Ken Starr in your life.
Well, Ken Starr to me is a personal hero. I would not be on the Supreme Court but for Ken Starr and what he taught me and how he inspired me, and watching his example. And I'm so grateful to Alice Starr and Starr daughters for being here, great friends, family to me. I worked for him in 3 different positions, in the Solicitor General's office, in the Independent Counsel's office, and then at a private firm, Kirkland and Ellis. And his decency, his courageous commitment to the Constitution, even when a lot of you are too young, but he was under a lot of heat in a difficult position, and he handled it with great courage and backbone. His preparation was unmatched. It taught me how to prepare. The students here, one of the things that separates the good from the very good from the great in the law is preparation, and he was amazing at preparation. His civility to everyone, how he treated everyone. Everyone was his best friend. He remembered details about your life even years later. And I saw the personal touch he brought to bear on everything. His commitment, as I said, to the Constitution and to religious liberty, which is something that I care deeply about, and I know many here care deeply about, and has influenced me as how I think about the First Amendment to the Constitution. So in so many different ways, he was a role model for me and taught me. He had been a judge, he was independent counsel, solicitor general, president of the great university, dean of Pepperdine Law School, committed also to public service. I encourage all of you to go into public service when you can, and Ken Starr, for me, was the example of commitment to public service. So just a tremendous loss not to have him with us still, but I think about his memory constantly, and it really inspires me to do more and do better, like Ken always did throughout his life.
So one of the things that happens is that the Supreme Court is often depicted as ideologically divided, and sometimes is divided along those lines, particularly in the cases that get the most media scrutiny. But there's often unanimous decisions.
Yeah.
There are cross-ideological coalitions that happen. I'm wondering if you can share some things that the court does to try to foster civility, civil discourse in the way it conducts its business.
Yeah, I think this is real important for everyone to understand, the students to understand. The personal relations among the 9 of us are outstanding. After every oral argument and conference, we have lunch together, just the 9 of us. If you do the math, that's like 65 lunches a year. That's a lot of lunch with the same 9 people. And the rule at lunch is you can't talk about work. You can't talk about cases. So you talk about same thing you all would talk about. We talk about movies and books and sports and current events and war stories and our family and kids. And you really get to know the other 8 people extraordinarily well. And what you really understand is all 9 of these people are so committed to America and the Constitution, and they're good people. And the fact that they have a different view of the free speech clause does not make them a bad person, right? And that civility that I think is fostered by the lunches, and we do a lot of other events together as well. But those lunches, I think, are the foundation for the personal relationships. And as you say, one of the important things, I think one of the things I knew but didn't fully appreciate when I got there is just how much time you spend with the other 8 people. And really, only those other 8 people. It's not like you have a committee, one committee, and then another committee. No, it's the same 8 every time you walk in. It's not, or on the Court of Appeals, different panels of 3. No, it's the same 8. So you really have to learn how to work with each of those other 8 people, and you get to know them so well. And as you say, Dean, one of the important things is that our cases are not all in the same division. About almost half of our cases are unanimous, and that itself is telling, given that there almost always had been division among lower courts about those cases, those issues. we come together 9-0. Oftentimes they're close to unanimous. And even when they're not unanimous, one of the key features, I think, and key attributes of doing well on the Supreme Court is the ability to compartmentalize. So you're disagreeing strongly with a colleague on one case. On the same day, he or she might be your biggest ally. So you can't let your disagreement on one matter or even irritation about one matter bleed over into the other case and affect your ability to work with that person on the other case. And some examples from last term, Justice Sotomayor wrote 2 very important opinions. I joined her in the majority in both. One, Glossop versus Oklahoma, a death penalty case out of Oklahoma, where we ruled for the death penalty defendant, ordered a new trial. Very difficult case, very controversial in Oklahoma. I joined Justice Sotomayor's opinion on that. Another about DNA testing for death row inmates, and I again joined her majority opinion in that case. Justice Kagan wrote a divided opinion that I joined on the non-delegation doctrine and administrative law doctrine that's been uncertain for many years, and I thought she wrote a tremendous opinion on that case. Justice Jackson wrote a unanimous opinion, important for us, on Title VII and the meaning of Title VII and how it applies to all people equally. So those are just a few examples, but those are not obscure cases. Those are big cases. We're spending a lot of time on those cases where that's not by some traditional division or some division that's depicted on the outside. And so that's happening all the time at the Supreme Court. The ability for the students here, the ability to work with others, even when you may disagree with them on something else, is critically important to being a good lawyer, to being a good lawyer to your clients, to being a good judge, to being a good public servant, I think to being a good person. And so we try to do that when we can.
I want to ask you some questions about your approach to the law and your work on the court. One of the things that jumps out to me about your bio, I think I have it right, that both of your parents were lawyers and your mom was a trial court judge in Maryland.
Yes.
And I'm wondering what that experience of having parents as lawyers as parents, how it influenced the way you see the role of the lawyer in society and your work on the court.
Right. So my mom's a huge influence on me. My dad is too. I don't want to leave him out, so don't tell him. But my mom's career path, she had been an American history teacher at high school, McKinley Tech High School. I'm an only child. So she started that in the fall of 1968 in Washington, D.C. when I was 3, teaching there. It was an all-black, 100% all-black high school in the fall of 1968 when race relations in America and D.C. were very challenging. And as a 27-year-old, she started teaching there. Her commitment to racial equality, equality for all Americans, her love of American history, and her willingness to walk the walk on those things was very inspiring to me and still is. I talk a lot about that. She, when I was 10, went back to law school at American University near our house and became then a prosecutor in Montgomery County, Maryland, and then Rockville, Maryland, and then later became a trial judge. So when I was in high school, she was a prosecutor. So my dad and I spent many after dinner listening to her practicing her opening and closing statements on us, which we're like, oh no, not again. But Eddie, listen.
Always persuaded.
Always, I was like, guilty. That's it, yes. Can I go watch the football game? Yeah, I got it, Bob. And, but to learn and watch her career, she's always, and 2 things she's always emphasized to me, since I'm an appellate judge and have been for almost 20 years, understand the difficult role of a trial judge. They're they're on their own. They're not in panels of 3 or 9, so that's a much more difficult job. And she always says, you guys are like the replay booth. You're frame by frame picking apart the call on the field that was made in the heat of the moment by the trial judge. So be generous to the trial judges and be understanding. She's certainly underscored that for me. And she was one of the early women in the legal profession in Maryland, prosecutor and trial judge. And she's always emphasized to me, and I tried to walk the walk on this, the importance of making sure the door is open. For us, it's hiring law clerks. That's a big deal for advancing people in their careers, and law clerks on the Court of Appeals and on the Supreme Court. Making sure the door's open to women applicants. There was a story right when I got on the Court of Appeals in 2006 about the scarcity of women clerks at the Supreme Court. And they said, then, those justices, well, the problem is the Court of Appeals judges from whom they hire weren't hiring enough women law clerks. And I took that, along with my mom's advice, as a charge, and I've made it my mission to make sure the doors open. And I've had more women law clerks than men. Whitney Hermendorfer just confirmed to the Sixth Circuit. Britt Grant is now in the 11th Circuit. So you see how these hiring decisions bear fruit 10 and 20 years later. Rebecca Tableson has her hearing for the 7th Circuit next Wednesday. Jennifer Mascott had her hearing for the 3rd Circuit a couple weeks ago. That's 4 circuit judges. 2 of them have to still be confirmed, so I don't get ahead of myself. That'd be 4 women circuit judges that were my law clerks. And I'm very proud of that. I thank my mom for inspiring me on that, and I think I've made a difference. So I'll just say on that, because it blends into collegiality. When I got to the Supreme Court my first year, I had 4 women law clerks. That was the first time ever in the history of the Supreme Court that a justice had that. And it meant that a majority of the clerks that year were women. And that also was a first in the history of the Supreme Court. And Justice Ginsburg, who's done as much as anyone for equality for all Americans and women's equality, talked publicly about that quite a bit and credited me with that. And then that was very meaningful generally, but it was very meaningful in terms of collegiality, that here was Justice Ginsburg, this icon, who had a different view than I do on some critical issues, was publicly congratulating and thanking me for that. And that really underscored for me the collegiality of the place. And, needless to say, my first year, I was not, the audiences let's put it this way, the audiences she was talking to didn't necessarily want to hear about Brett Kavanaugh and hear positive words about me, but she didn't care about that at all.
You got some water right there.
Yeah.
One of the things that these students have studied, will study, or are studying is the Constitution. And I'm curious about how you
Carry it around.
it's well used, it seems. Just how you approach interpretation of the Constitution. What's your philosophy in terms of constitutional interpretation?
So I'm an originalist, which means I care about the words of the Constitution. And, you can't see, but this thing's tattered. I've had this. Somehow I've not lost this over the last 30 years. And I clerked for Justice Kennedy, and he signed it in there for me. And I like to say this is a symbol for me of how the Constitution endures, even when I've carried it around. And look, the words are all marked up inside. I've got highlighting and arrows, and the words matter. The words of the Constitution are law. And so I think it's really important to recognize that, that my voice is going out. So the text matters. And, the original meaning of the text matters and the history behind that. So that's what I think is important with respect to the Constitution. And we have to understand how that history operates with respect to the text.
Has your philosophy ever led you to an outcome in a case that maybe you wouldn't have wanted if you were sort of a king instead of a Supreme Court justice? You would dictate a different outcome than your philosophy leads you.
Yeah, that happens, of course, all the time, where you are interpreting a statute and it comes, well, if I were a member of Congress, I wouldn't have written the statute this way. And it comes out quite a bit differently. And so I think it's important, though, as a judge, when you asked about what's your judicial philosophy, it's very important as a judge to know your role. What is my role in the system? My role is not to make the policy decisions. My role is to interpret the law and to stick to your role, to stick to the words of the statute, to the text and history of the Constitution. Now, I mentioned text and history on the Constitution, but precedent also really matters. For all the students here, whatever you're doing in law, always ask yourself, whatever it is, how has it been done before? Whether you work in the Senate or the House or the judiciary or work for a business, knowing what the text of the relevant legal document is, knowing how it's been done before is also really important. the precedent, the judicial precedent. For us, that's very important. For us, that was very important in the White House. How have presidents done this before? That's very important as well. So text, history, and precedent, and that leads you to an answer on the Constitution or statute. But you're going to have issues where you think, this is not what I would do if I were starting from scratch. And you have to be a good judge, you have to be able to separate your policy views and your moral views from what the law is. You take an oath to uphold the Constitution, not to uphold what you think the law should be. And if the law should be changed, that's for the people to do through making constitutional amendments, or that's through for Congress and the president to do through the legislative process.
Well, this next question may go a little bit to the keeping the personal and moral views separate. Baylor University has a Christian mission. And a number of the students wanted me to ask you, and I know you're a person of faith, a number of the students wanted me to ask you what role your faith plays and maybe doesn't play or can't play in your own work.
So I think it's very important that I remember my role as a judge for all Americans, for 330 million Americans. It's not to impose my moral views. Again, I took an oath to uphold the Constitution. At the same time, my faith is very important to me personally, and it helps me, I think, be a better person, to understand people better, to commit to public service, to help me deal, frankly, when there's criticism. If you don't like criticism, this is not a good gig. Being a judge, being in public office, and to withstand that criticism and to keep your balance, I think is a good way to put it, to keep your balance amidst all the criticism. Your personal faith, your family, your friends are very important. My first year on the Supreme Court, I'd find myself often going over to St. Joe's Church on Capitol Hill. I'm Catholic, and for the noontime Mass, the 12:10 Mass, because I just thought, I need to get out of this building, and I need to just go be in a place where I can be with myself and God for a little bit and refocus. And I think that's really important. If you're a person of faith, your faith is very important in how you treat other people. It's very important, I think, in understanding the bigger picture and not getting too dragged down by the daily moment.
Yeah. I want to ask you about some sort of current issues and climate. One of the things you've joined opinions emphasizing the need for lower courts to follow Supreme Court precedent. And I'm wondering, what do you see as the challenges in sort of maintaining hierarchy and consistency within the federal court system?
Yeah, I mean, I don't want it to sound arrogant or overbearing. We're not infallible. We are final, as it's famously said. And I think it's important for the orderliness of the system that precedent be followed, and including, and that the law be followed by not just by judges, but by other public officials, of course, adhering to the law. And I'd written a book on precedent when I was on the Court of Appeals, along with now Justice Gorsuch and a few other judges. So I spent a lot of time in my life thinking about precedent, both this perspective of lower court judges following Court of Appeals or Supreme Court precedent, and also the Supreme Court, how it handles its own precedent, because we can overrule our own precedent at times. We don't do it often, but we do it sometimes. But I think for the orderliness of the system, it's important. Now, again, going back to my mom, she's like, well, you guys need to be clear. You want the lower courts to follow. And that's a fair point, and one that I think we could all commit to as well. I think that's an important point, that we have to be clear. And frankly, going back to the 9, one of the difficulties about having 9 people is you're going to, by definition, compromise and have consensus forming. And compromise and consensus sometimes comes at the expense of clarity, because 2 people might have different views on a particular way to phrase something, and you kind of meet in the middle. And meeting in the middle sometimes is not always the clearest for the lower courts. When I was a lower court judge, I would sometimes say, how's the Supreme Court, how do I interpret this footnote? And now that I'm there, I realize quite a bit more. Well, that was probably the product of two people or a group of people trying to work out a disagreement in doing that. But precedent's very important for lower courts. When I was on the Court of Appeals, I said lower court judges have an obligation to follow Supreme Court precedent in letter and in spirit. And I think that is important. Again, I don't want to sound overbearing about it, but I think it's important for the stability, really, and orderliness of the system.
So you mentioned important for lower courts to follow Supreme Court orders and public officials. So I'm wondering if you worry that the president or any president would defy a Supreme Court order, and what, if anything, can be done to prevent that, make it less likely, or to counter it in the event that it happens.
I don't worry about it.
That's reassuring.
I think American history gives me reassurance on that. So I'll just say I don't worry about it. But
Okay. I will. That'll start me.
that was it. I'm usually long-winded, but
Yeah, I love it. That was short.
threw them off a little bit.
It did. I expected an explanation. I knew you want to say something.
I think our history shows that even in the most momentous and difficult times, when the Supreme Court has issued a final order that says public official must do something as a matter of law or cannot do something as a matter of law, and that's a clear, and going back to the clarity, and that's a clear order, that's been followed. And I think our system depends on that. Our independent judiciary and ultimately our constitutional system depends on that. And I have confidence that that will continue.
What role, if any, do evolving societal norms play in constitutional interpretation or just in the work of the court more generally?
So I think it's not for us to update the Constitution. It's not for us as judges to update the laws passed by Congress. It's for us to apply the Constitution as written, informed by history and precedent, and to apply the statutes passed by Congress and the president as written. Congress has the job of updating statutes, and so we step outside our role. To go to your question about maybe I don't like the decision, and we go outside our role and we say that statute's really not a good statute anymore, so we should rewrite it. That's outside the judicial role, in my view. But Congress, under our system, has the ability to update statutes and often does when they become aware of problems. Now, it's hard to pass legislation, I get that. But that is Congress's role, not our role, is to reflect the evolving societal norms. So, too, there's a constitutional amendment process for updating the Constitution, which we don't do much anymore, which I think is not great, because I think it should probably happen more often, but certainly a lot of the key provisions of the Constitution are constitutional amendments where the people came together to amend the Constitution, to update the Constitution, the most important obviously being the 13th, 14th, and 15th Amendments to the Constitution, which led, of course, to Brown versus Board of Education, which I always say is the greatest and most important decision in Supreme Court history, Brown versus Board of Education. So that principle of equality is a constitutional amendment and critical. So I think we got to be careful. Now, at the same time, I don't want to be misunderstood. The principles in the Constitution we cannot change and rewrite, but we can apply them to modern situations. So just to give an example, the free speech clause, we can apply to the internet, even though the internet didn't exist back in the founding. The Fourth Amendment can apply to cars, even though cars didn't apply. So we are applying the principles to changing technologies, changing circumstances, but we are not rewriting the principles. That's what I think is the core kind of, I don't like the phrase, I don't like to get into the whole living Constitution. The Constitution, that's why I like the word enduring Constitution. It's an enduring Constitution in the sense that it still applies and applies to modern circumstances.
So, again, telling you something you know, but the court recently has sided with the Trump administration on some matters, and you see in the media some commentators saying that reflects a partisan bias on the court. And I'm wondering what you would say to critics about partisan bias, one way or the other.
Right. So this goes to the Chief Justice's comments that judges are like umpires. which I think is a great line. And it's important for us to recognize. I spent a lot of times on the sidelines of my girls play sports, and what makes a good umpire, a good referee? Right? We're in a stadium. Did you ever walk out of a game and say, "God, we lost, but the refs were great"? Okay. I think that's never happened in American history, actually, where someone walked out of a game and said that. And so, too, I think in the moment, we have to recognize that the losing party is, of course, not going to like the decision. So the way we have to be like umpires, what makes a good umpire? What's the number one thing you hear yelled by a parent who's out of control on the sidelines? Usually the number one thing is, call it the same way down there. Call it the same way down there. And what's that getting at? That's getting at what I think is a key attribute of a good judge, which is consistency. You have to be consistent. You have to be neutral and consistent. And by consistent, I mean calling it the same way for both teams, whether Republican or Democratic, whether business or labor, whether the developer or the environmental interest. You have to apply those principles, and you have to apply them the same way for everyone. And so it's, I think, hard to judge based on one case or even a series of cases without taking the sweep of how's the court been applying that principle over the time. Did they apply the same principle the same way with Biden and Bush and Obama and Trump? And I think, I'm sure we can do better, but I think we try hard, each of us as the 9. We have different principles maybe, but we try hard to be consistent in how we apply those principles across administrations. And that's the objective that we try to live up to. I know on some matters I ruled for President Biden on very controversial immigration matters, COVID matters. I ruled sometimes for the Biden administration. I got a lot of criticism for those. That's all forgotten at the moment. But that's the point. Trying to be consistent. That principle that I applied there, I need to apply here as well, even though it's a change of administration. You're going to get a lot of heat in the moment, just like the refs do, right? Just like the umpires do. But if you're being consistent with your principles, I think hopefully over time the people will understand that.
Do you, because there are different principles, you don't all have the same principles, is it possible for you to build consensus? And I guess you've already talked about that it is possible, but how do you go about doing that? What techniques do you use or see used on the court to sort of cross those divides?
Yeah, and I think, again, this is important for the students, which is if you're kind of my way or the highway, I want 100% of what I think's right, that's difficult to build, to find 4 other people or hopefully 8 other people who are going to agree with you. So you have to stick to your core principles. So I'm not saying sacrifice your principles, but also be willing to find common ground, and maybe 80% of what I think is the perfect answer is good enough for today, sufficient under the day, and being willing to have an open mind on that. I say oftentimes that one of the important things for being a good judge is a lesson I learned when I was in high school. My high school an English teacher, Chris Abel, he taught us To Kill a Mockingbird. And I have the copy. I'm a pack rat, I guess, but I have a copy of the To Kill a Mockingbird I had from back.
I was hoping it wasn't in your other.
Well, it's right here. But it's in my office. If you come visit my office, the To Kill a Mockingbird and my notes from back then are written on the inside cover. And he made us do a paper on, and it's written right there in my dad's handwriting, standing in someone else's shoes. He wanted us to do a paper on that. He thought that was the lesson of the book, standing in someone else's shoes. And to be a good judge, you have to stand in other people's shoes, the litigants, the other party, the losing party, but also your other judges. Stand in their shoes. Okay, Sonia thinks this, Sam thinks that, Elena thinks that. Stand in their shoes. Why are they approaching it from that way? Can I find common ground? And Justice Breyer, when I got to the Supreme Court, came in and he said, he's the greatest guy, and he came in and he said, here's one word of advice around here. Listen. Great advice. Listen. Stand in other people's shoes. Learn. Be willing to find common ground. And that's how that kind of makes the court run, I think, and operate. We're still going to have those times where, nope, my core principles and your core principles are such we can't bridge this divide. And then you, as I said earlier, compartmentalize and you're like, well, we're not going to agree on this case. One of my favorite phrases as a judge is next case, because we got to put that one aside, go to the next case, see if we can work on the next case and find that common ground. It's really important. So I think that I keep that in my office, that standing in someone else's shoes, because I think to be a good judge and to be a good person, going back to your initial comment today about what's current events, standing in other people's shoes, really important.
Quick follow-up there. Efforts to bridge the divide. Then you come to the moment we can't bridge the divide. Our principles are just too different on this particular issue. How do you handle that situation? What's your advice for the students when we can't bridge the divide? We disagree.
What I like to do is say I respect your position, but ultimately I see it differently. In our conference room, the 9 of us are in the conference room deciding cases and deliberating over cases. No one else is in there. There's no staff, which is extraordinary in Washington, I think. And in my 7 years there, I've never heard someone yell, never heard someone be rude, be acerbic, sarcastic. It's so respectful in that room. I sometimes think if there was a secret camera and audio that the American people would be so impressed about the preparation level that Ken Starr taught me, but respect for one another and respect for one another's views. Of course, if there were a camera and audio, we'd probably all act differently, but that's the problem with that. But I think it's very respectful, and just to have I respect your position, but I disagree. And as a judge, when I'm writing opinions, this goes beyond the judges. The losing party, going back to the losing party in the game, and the respect for our constitutional system. Our system, we can't be chasing popularity, okay? Because we have to rule for death penalty defendants, for unpopular free speech claims, for minority religions, free exercise claims. We cannot be chasing popularity in individual cases. But we need to be worried. We can't be oblivious to the public view of the court. I think that's a mistake too, and we have to make sure that it's respected. Consistency goes to that. Consistency and neutrality and trying to do what we can, always knowing there are going to be critics, right? Consistency and neutrality. But making sure, and this is really hard, the losing party respects the decision. That's going to be hard because like a losing team, they're going to hate the decision, right? And so I try hard at oral argument to be very civil and respectful to both sides, even if I have a lean, and never to be too sarcastic or acerbic. And I try very hard in my opinions, and I know I fall short, but I try very hard in my opinions to make sure the losing party is respected. And, I got to commit to that and recommit to that all the time, because the losing party has to feel like they got a fair shake. At least they had their argument heard. They're not going to be unhappy. But to the extent you can do that as a judge, I think that, each little thing we're talking about is a little brick in the wall of our constitutional system. So every little day, every moment with a lawyer, every opinion you write, every interaction with your fellow judges is important in that front.
One of the things that some people see as a challenge, current challenge to respect for the court, is the emergency docket, so-called shadow docket. Would you teach our students, those who don't know, who may have been in law school for all of 2 weeks, will you tell them what the emergency docket is, and what, if anything, do we need to do to ensure that it's fair and transparent?
Yeah, so I call it the interim docket now. You can call it the emergency docket. I'm not allowed to use the term shadow docket, but critics use the term shadow docket on it. I went through, in 2018, 32 hours of Senate confirmation hearings being questioned about everything possible. I never got a question about this, which shows that it's somewhat of a recent, it's not a recent phenomenon, but the volume of it has grown a lot. So let me try to explain succinctly what's going on. So a new statute's passed by Congress, or more commonly, a new regulation or executive orders issued by a president. It could be Obama, Biden, Trump. The Supreme Court will ultimately review, if there's a challenge, as there often is, the legality of that executive order or regulation. Litigation, as we all know, takes a couple years to wind its way through the system, get to the Supreme Court final answer. Okay, so that 2 years from now, we'll have a final answer on legality. what is the legality of that regulation or executive order in the interim 2 years before that decision? Can the president enforce that executive order, or can he not enforce that executive order during the interim, tomorrow, right? That's itself a really important question. And what the interim docket does is usually make a decision on the interim status, yes or no, for those 2 years. And I'm using 2 years as a shorthand. And it's really arisen because, and you mentioned this earlier, Dean, Congress is passing less and less big legislation, difficult to get things through Congress. So presidents don't, I saw this with President Bush, they don't come into office like, trying to be passive. They want to get things done for immigration policy, for healthcare policy, for Social Security, for retirement income, whatever it might be. And they can't get new legislation through to implement their agenda, so they try to issue new regulations or executive order within existing statutory authority. And they'll push the envelope, right? Because they want to get things done. They think it's for the good of the American people. And we'll be the arbiters of, and they're doing more and more of that. If you heard President Obama use the phrase, I have a pen and a phone, that's this. Okay, that's more regulations, more executive orders, and obviously President Biden during COVID did a lot of them. President Trump has done a lot of them. And that's what we're assessing during the interim status, whether a particular EO or regulation can be in play for the next year or two until a final decision.
And in terms of anything we need for better transparency, what are your views on that?
Well, that's a complicated question, and we're working our way through it. Sometimes we issue opinions, sometimes we don't. I think the danger of issuing an opinion to explain ourselves is that will potentially create an impression that that's our final view on the legal issue, and we haven't gone through our process that we normally go through of oral argument and briefing and deliberation around the conference room and months of writing and rewriting. So there's a danger of too much writing, but at the same time, because these are significant decisions in and of themselves, what's the status tomorrow? The American people sometimes want an explanation. So we're balancing two very difficult things there that we are, I think we struggle with on each case. I haven't found a perfect answer to that yet. I mean, I think we're working on it kind of on the fly as best we can.
Yeah. Well, in any given year, about 10 to 15% of our graduates go to their first job is clerkship. And I'm wondering what you see as the characteristics of a good law clerk, because you've had, as you mentioned earlier, you've had a lot of them.
Yeah. So I think about what makes a good law clerk. I think about for also what makes a good judge. I think I'm constantly trying to think about how to get better. And I think the students should too. I've been a judge for 20 years, but I want to get better. I read a story on the way down yesterday about Alcaraz, the tennis player, how after he lost Wimbledon, he redoubled his efforts to get better. Like the greatest player in tennis, to get better. And for judges, students, we can all get better. We could all improve. So what I think about for myself is, I think also for law clerks. And here are a couple of things I think about. By the way, we don't have the 9 of us on the Supreme Court. We are super competitive people. We'd love to have a grade, a batting average, something, but we don't. You can't. Polls are not a good evaluator. Criticism you can't pay attention to. So how do you measure yourself? How do you look? And I'll say to my daughter, Liza, how'd you do in school today, Liza? And she'll be like, yeah, I did well, Dad. How'd you do? She's 17. So, of course, and I think about that. How did I do? And so I think about principles that I learned early on, and I try to live up to those. So one of those, which I learned early on from Father Byrne at Georgetown Prep, be prepared. Be prepared. The person, I've learned it from Ken Starr, I saw him walk the walk. Be prepared as you go along, and preparation separates the good. And so I asked myself, was I really prepared for that oral argument? There's kind of preparation. Was I prepared for class? Was I prepared for that exam? Was I prepared for that hearing? And there's kind of preparation and then really prepared. So I measure myself. I look at it, was I really prepared for that? Second thing, the ability to work well with others, right? We've talked about that, standing in someone else's shoes. Really important. I need law clerks
I say in my interviews with law clerks on the Supreme Court, I need you to be able to work with all 8 other chambers, with all 32 other clerks, be able to work well with each of those people, being able to work well with others, to be a team player. I use the phrase team of 9 about the Supreme Court, and I think that's really important. So to be a team player, to be a good law clerk, I think is really well. I think for a judge, and I think this matters for lawyers and law clerks and whatever you do, be not afraid. Be not afraid to do the right thing. I did, my music teacher in high school, Gary Daum, used to sing that hymn all the time. Be not afraid. And I thought about that lots of times in my career. I saw it with Ken Starr. Be not afraid. Be not afraid. What do I mean by that? Be not afraid to resist peer pressure. Be not afraid to stick up for your principles. Be not afraid to do the right thing. Be respectful, but be not afraid to do the right thing. And then the last thing I want is someone who's a positive influence. And I think about myself. I want to be positive and optimistic. Like today I started with this dark day in America. Yesterday was a dark day. But when I walk in, I work for President Bush, as we discussed. He had a painting on the Oval Office called Sunrise Side of the Mountain by a painter named Tom Lee in West Texas. Live on the east side of our mountain, the sunrise side, see the day that is coming, not the day that is gone. And you meet when you go through the confirmation process, to which you meet individually with senators. I met with 65 senators individually. And they would start usually by saying, this is a rough process, we know. And I'd always say, and my team would start rolling their eyes, I'd always say, that's okay, Senator, I'm on the sunrise side of the mountain. I'm optimistic, I'm positive about this, right? And when I got confirmed, my former law clerks got a replica of the painting by Tom Lee, and I have it framed above my desk at the Supreme Court, sunrise side of the mountain. So when I walk in the morning, I see that it's a reminder of my great days with President Bush, but it's a reminder to be optimistic and positive, even in the midst of tragedy, even in the midst of September 11th, the remembrance of, President Bush leading us out of the darkness there, or the darkness of yesterday. So living on the sunrise side of the mountain, to translate that to day, just to being a positive person, not the person who's the complainer, not the person who's saying, woe is me. We all have those moments. We're all human, so I certainly do. But the person who's positive and optimistic. And that's kind of how I measure myself each day. Was I prepared? Did I stand in other people's shoes? Was I not afraid to do the right thing? Was I positive and optimistic and not cranky and what have you? And I think those things are kind of how I grade myself on a daily basis. And that's what I'm looking for in people who work for me as well.
We're just about out of time here, but you're sitting in front of most every law student at Baylor Law School, and I'm wondering,
Well-dressed law student.
They're very well dressed. I'm just wondering what you think of their career choice to become a lawyer.
Yeah, well, I'm very supportive. A law degree, especially from an amazing institution like Baylor Law School, can give you the tools to do so many different things in life. And you might be a practicing lawyer, you might be an academic, you might work for a business, you might run for office. I encourage public service. Get involved in community service and public service. It gives you the tools to understand our system. It opens doors. You might leave the law entirely, but it gives you an understanding then of how the law works, which affects all aspects of our society. So I think a law degree, I'm pro. I'm pro. I don't, coerce, but I am pro law degree in the sense of it gives you tools and opens doors to contribute to society and have a fulfilling life. And so I am grateful to all of you for pursuing that path. The one kind of point of emphasis I put on is some point in your career and your life, find opportunities for public service, like Ken Starr did throughout his amazing career. Find opportunities to give back. Find opportunities to do. I always talk about Matthew 25 to help the person in need, to help the public. The Matthew, to feed the hungry, clothe the naked, to visit the sick, and to contribute in small ways or large ways, in individual ways or more broad ways to the public good is really something that I think a law degree, particularly from Baylor, equips you to do. And so I encourage you to get involved, follow the Ken Starr model of public service and get involved. And
don't feel, one last thing on that, don't feel like there's one path to success. There are lots of different routes, and there will be disappointments. Life is full, there'll be times where a door closes, but another door will open. And that happens to all of us, happened to me, happens to all of us during our careers. But you are equipped coming from this law school with what you've learned at this law school to pursue a lot of different paths in the future. So I'm grateful that you've chosen that path, and I hope you give back, as I know you will.
Justice Kavanaugh, thank you so much. I want to take just a moment here at the end to thank you, President Livingstone, for being here, for your commitment to civil discourse. Alice, thank you so much for the role you played. And John and Marie, thank you for making this kind of conversation possible here at the law school. And Justice Kavanaugh, I said this to you before we came on the stage, but particularly today, after yesterday, being willing to come to Waco and have a civil discussion about your work and role on the court and the court itself is incredibly important, and we are deeply grateful to you for that.
Thank you.
I'm going to ask all of you, I'm sure you can understand, Justice Kavanaugh is a somewhat busy man. We're going to let him exit this way and go out the back, and I'll ask you to remain in your place while we do that. But as he leaves, let's thank him for having come here and talk with us today.